All right, so welcome to the third seminar of our 2011-2012 season for the Nathanson Seminar Series on Legal Philosophy between State and Transnationalism. Today we're very fortunate to have with us Professor Neil Walker, who is Regius Professor of Public Law and the Law of Nature and Nations. Wow, what a grand title. At the University of Edinburgh. Professor Walker holds an LLB and a PhD from the University of Strathclyde. And before moving to Edinburgh, as a successor entitled to another illustrious Neil, that's how they call them in Scotland, Sir Neil McCormick, Professor Walker also held chair professorships at the University of Aberdeen and at the European University Institute in Florence. He's held also a number of visiting appointments, including at Columbia, Cornell, Tilburg, the University of Toronto, and right now at New York University. His main area of expertise is constitutional theory. He has published extensively on the constitutional dimension of legal order at sub-state, state, supranational, and international levels. He has also published at length on the relationship between security, legal order, and political community. He maintains a more general interest in broader questions of legal theory, as well as in various substantive dimensions of UK and EU public law. And to this effect, in 2008, Professor Walker was appointed by the Scottish Government to conduct an independent review of final appellate jurisdiction in the Scottish legal system. Today, he will speak to us about constitutionalism and pluralism in a global context. As his commentator today, we are also pleased to welcome our very own Professor Per Zumbansen, who is here at Osgoode, Canada Research Chair in Transnational Economic Governance and Legal Theory. And Professor Zumbansen is also co-director here at York of the European Union Centre of Excellence. He holds degrees from the Université de Paris, Harvard University, and I can do the German version, but the University of Frankfurt, including both a doctorate in law and the Habilitation. So yes, he is one of those Herr, Professor, Doctor, the only one, in fact, that we have here at Osgoode, and so we are very proud to have him with us today. Professor Zumbansen also held many visiting appointments, published numerous leading books on transnational law and governance, as well as many papers in leading journals. So we're very glad to have today with us both Neil and Per. And so a few words about our format. As usual, Professor Walker will make a presentation for about 30 minutes, which will be followed by a response or commentary by Professor Zumbansen of approximately 10 minutes. And then we'll give a brief moment to Professor Walker if he has remarks to make about the response. And then we'll open the discussion to everybody so that everybody has a chance to chip in and contribute. So thank you very much, and without further ado, Professor Walker.
Okay, thank you. Thanks for inviting me, Francois, and also Per. It's great to be here. It's the first time I've made it to your I was going to say spanking new campus, but spanking new building in existing existing campus. Not quite big enough, but it's getting there. But it's great to be here. I have been at Osgoode before, but I think in a different venue. Downtown, wasn't it? Yeah. Okay. So let me say something. I can't obviously read out, I won't try to read out the entire paper. Let me say something about the genesis of the paper, because it might help put it in context. A number of years ago, I wrote a piece in the Modern Law Review called The Idea of Constitutional Pluralism, which was one of a number of articles at that time which caught the imagination of a certain type of European legal scholarship vis-a-vis this new idea of constitutional pluralism, which I will describe in due course. A number of years later, when lots of people were writing about constitutional pluralism, a seminar was held in Oxford by a number of people, including a couple of my ex-graduate students, looking at the state of constitutional pluralism today, so to speak. And I basically, it was my job, it was my role in that context to look again at constitutional pluralism 10 years on, but looking at it more in a global context than a European context. And so what I saw myself as doing was trying to understand what kind of insights that constitutional pluralism brought to the world of transnational law, why these insights seemed particularly pertinent in the context of the European Union, and the extent to which these insights might or might not transfer to the global stage. Because increasingly, ideas of pluralism, constitutional pluralism, there are many forms of legal pluralism, but constitutional pluralism increasingly was being deployed in a global context and not just in a supranational pan-European context. So that's what I saw myself as doing. And so let me start from the beginning and what constitutional pluralism is or is not, and why it might have been relevant or particularly relevant in the European context, and why it's problematic for us to assume that whatever relevance it had in the European context would easily transfer to the global context. So constitutional pluralism isn't one idea, it's a number of ideas, and it's a number of reasonably either simple ideas or undeveloped ideas. So I'm not talking constitutional pluralism up. It's a label. It's a bit like global administrative law. It's a label, you know, and it gets its power from its thinness and its inclusiveness rather than from its thickness and its specificity. But basically, the constitutional pluralist insight was a mixture of a kind of a recognition and a hope associated with that recognition. The recognition was that if we look at constitutional sites of authority, and we assume that constitutional sites of authority are typically state-based, then one of the basic assumptions, one of the basic premises associated with that state-based constitutionalism no longer necessarily held true in a globalizing world. And of course, the basic assumption was that constitutions were hierarchical structures of law. They were based upon an internal hierarchy. They were based upon the idea of fixed boundaries, of comprehensiveness of coverage within these boundaries. And they were also based upon an idea of mutual exclusivity. So state constitutions were seen as being mutually exclusive. Of course there would be boundary questions, but effectively they were seen as being mutually exclusive. And that mutual exclusivity, that the way in which external sovereignty fed into internal sovereignty, that mutual exclusivity meant that these criteria of internal hierarchy, comprehensiveness, and close boundedness could apply. There was a kind of mutual recognition of these between the states of the world. Now, of course, this is a narrow legal thesis, is one which of course doesn't take account of all sorts of power asymmetries in the world. It's one which doesn't take account of various forms of imperialism, legal and non-legal. But it is a theory of the state. It's a juridical theory. It's a juridical imaginary about the nature of the world, which, at least to some extent, described one part of the world in legal terms. Now, what constitutional pluralism says is that increasingly we have polity sites where that idea of mutual exclusivity no longer applies. What we have are overlapping polity sites. We have forms of political community with legal force and legal authority which overlap states. And the European Union was seen as being the strongest example as a very, very well-developed supranational organisation. But one, of course, can imagine many others. Even at the time when I was writing, there were many, many other ways in which we could think about this. We could think about other regional free trade organisations. We could think about perhaps the UN to some extent. We could think about the World Trade Organisation, etc., etc. Greater, more or less persuasive cases could be made about the development of other forms of transnational polity. And the idea was that increasingly these transnational polities, which were often defined in functional terms rather than territorial terms, overlapped the area of national polities. And the consequences of that was that we had to rethink some of the ideas of hierarchy and exclusivity which were associated with our traditions of constitutional law. There was an overlap, and so we have to think in more heterarchical terms, or we have to accept that there would be clashes between different notions of supremacy or final authority between different constitutional orders. So, so that was the analysis. That was the diagnosis, very, very loosely. The hope associated with that diagnosis is that something normatively attractive would come out of this. Something normatively attractive would come out of the fact that different legal and constitutional orders were no longer were in a relationship which was not one of mutual exclusivity, but it was one of overlap, but one where there would be no trumping rule of normative authority which would allow one polity to prevail over the other. And so new forms of interaction would be required between different different polities. And of course, the basic context of this was the European Union itself, and there was lots of at least superficial evidence that there was a developing world of constitutional pluralism there, because there were many contexts within which national courts in Germany, in the UK, in Denmark, in Spain, throughout the European Union, were asking questions about the limits of the authority of the European Union, and were asking questions about the relationship between its putative constitutional authority and their own putative constitutional authority. So in early years, for example, there was a famous Solaya jurisprudence involving the relationship between the German Constitutional Court and the European Court of Justice, where the German court was worried that constitutional power was being abrogated at the European level without sufficient regard for human rights. And it effectively said that it would withhold its justification for that transfer unless it was satisfied that human rights were being protected at the European level. And there was a series of jurisprudence by which the German Constitutional Court gradually satisfied itself with that. So, but there's lots of other cases and lots of other contexts where we can see similar clashes or similar oppositions between national constitutional authorities, perhaps over questions of the transfer of treaty powers, perhaps over questions of the transfer of criminal justice authority from the national level to the supranational level, perhaps over a whole range of other questions, usually in areas where supranational authority was claimed in an area of traditional national authority. That would cause conflict or the possibility of conflict. And what the constitutional pluralists were saying was that
very nice.
Sorry, we're in a seminar right now? There we go. Sorry, guys. Does anybody know how to... I think that's good. Take the plug out of the back. Sorry, Neil.
Who was that? Right. Sorts of things that happen in a pluralist world. Yeah. Right, okay.
Not it explodes.
Okay, anyway. So, did I get an extra 2 minutes for that? Sorry, I've lost my stride. So, okay. So the question was, you know, what is actually going on in these sorts of situations? And as I say, the constitutional pluralists wanted to think that something normatively attractive was going on, okay? But of course, constitutional pluralists were often treated by skepticism by various others. And basically, there were three types of skepticism, which I want to outline in the abstract, say something about them in the context of Europe, and then move on and say something about the more generally in the global context. And these forms of skepticism, we can actually discover them simply by parsing the word or the phrase constitutional pluralism. Okay, so one kind of skepticism said that constitutional pluralism is always in danger of collapsing into a new monism. In other words, it's not necessarily going to be pluralist at all. That even if you look at it in the context of the European Union, clearly both levels, the European level and the state level, have monistic pretensions in many cases. Their self-understanding is still very much in monistic terms. They see themselves not necessarily part of a bilateral or a multilateral power structure, but as single points of power. We'll come back to that point in due course. So one criticism is that constitutional pluralism is always tending to collapse into constitutional monism. As Nico Krish says, there's something basically fundamentalist about constitutionalism. Once people start using the constitutional lingo, then they see themselves in monistic terms. And indeed, if you look at the recent German Constitutional Court decision on Lisbon, on the legality of the Treaty of Lisbon in German law, they actually paint a story of there being two narratives of constitutionalism, their narrative and the European narrative. And so they're actually saying, yes, there are two. Pluralism isn't pluralism. What we have here are two monisms, two different sort of monistic perspectives. So that's one kind of skepticism. A second type of skepticism, which is related to it, is that pluralism is simply plurality. That pluralism suggests an attitude towards plurality, which involves some kind of reconciliation of the parts. Okay, plurality is just a variety; it's just difference. Pluralism is taking difference seriously and reconciling that difference. So again, the argument is that that just because legal orders overlap, it doesn't mean that they put themselves in a pluralistic relationship with each other. They may simply overlap. The world may simply be chaotic. There may simply be overlapping legal orders who do not know how to reconcile their relationships with each other. So that would be a second kind of criticism at the analytical level. The third type of criticism is that if there is something called pluralism here in law, then it's not best thought of as being constitutional. In other words, if we can avoid the extremes, the equally unsatisfactory dichotomous opposites of either a new monism or a plurality which isn't pluralism, then we're most likely to be able to do that if we don't use constitutional language. Because constitutional language is supremacist, it is authoritative, it is monistic in its nature, and it does not lend itself easily to the very idea of pluralism. Whereas if we look at other ways of thinking about law, and for example, if we look at the history of, say, legal pluralism, where what we're talking about is the relationship between official legal orders and unofficial or customary legal orders within a polity, then the fact that often in these cases the different orders aren't each claiming the constitutional label actually creates a more fluid and a more versatile context for some kind of negotiated relationship between these orders than we have when both of these orders think of themselves in constitutional terms. Okay. So, now, my answer to that in the European context, and many people's answer to that was, well, the European context remains interesting from a pluralist perspective, but interesting in a kind of non-threatening way, okay? Because in the European context, there are already so many bridging mechanisms built in. The European Union is a sophisticated legal system. It has ways in which the courts speak to each other through the preliminary reference procedure. It has methods for the translation of supranational legislative norms to the national level. It has sophisticated relationships between the executive at the supranational level and at the state level. All of these things are catered for. There's a whole bunch of bridging mechanisms between the different legal orders. There's also a deep cultural affinity that what we're talking about is a number of socially similar states, who voluntarily have entered a certain type of social and economic project. So there's a kind of sense of a common cultural horizon involved in this as well. So basically, if we're looking at constitutional pluralism in the European context, then the fact that we have the occasional highlight case doesn't gainsay the fact that for most circumstances, this is a context where pluralism is not staring into the abyss. It's not that if there is some standoff between the European Court of Justice and one of the national courts that the whole thing is going to fall apart. There's actually such a stable legal and cultural and political substructure, at least until the latest Euro crisis, that and we'll talk about that later. That pluralism, there's a kind of indulgence of constitutional pluralism in that context. I talk about it being a regional comfort zone for pluralism. Now, the reason I've dwelled so long in the European area is that not only was a lot of work done in that area, and that's where it started, so there's a kind of historical truth in this, but also I think that it, to some extent, it distorted the picture. It gave people a distorted and perhaps a complacent sense of what was possible in the context of constitutional pluralism, okay, by looking at the European level. So when people started using the language of constitutionalism and to some extent the language of constitutional pluralism in the global context, and to some extent that was on the coattails of the theoretical literature on constitutional pluralism in the European context. But it was also something which was stimulated by events and by people's perception of events. Perception that that kind of picture of overlapping polities, which existed in a kind of structured way in a European context, existed more broadly in a much more unstructured way globally. That this wasn't just a European story, and if anything, the European story was not necessarily typical of the global story. Okay, so the question then was that the sorts of concerns which arose, the sorts of skepticisms that one might have about constitutional pluralism in the European context, what happened if you took that to the global context, and what happened to the hope associated with the diagnosis that these kinds of that pluralism could actually be something which was normatively attractive, normatively generative, normatively productive in these sorts of areas. And again, let me look at the three sorts of forms of skepticism looking at constitutional pluralism in the global context, and with particular regard to how constitutional language and constitutional theorization has developed in the global context. So the first type of skepticism, again, goes back to what I call the kind of incipient monism, the fact that the language of constitutionalism always tends in a monistic direction. Now, you might think that that's a very unlikely criticism at the global level, that whereas it's possible to conceive of an incipient movement towards a federal European polity, then we cannot imagine anything like that in the context of the globe. We cannot imagine that in terms of an idea of a global state or whatever. But of course, it's not as simple as that, because much of the language of global constitutionalism has actually been quite monistic in nature. Not necessarily at the level, or certainly not at the level of the global state, but at the level of certain types of global normative order, whether it be the normative order associated with the United Nations, or the United Nations Security Council, especially in its various activities after 9/11, and when it took more clearer and more coercive forms of both legislative and executive power at the global level, or whether it be in the level of notions such as world order treaties, international customary law, jus cogens, etc., etc. These ideas, these are all ideas which are monistic ideas, and it's no coincidence that those writers who have been enthusiastic about the notion of constitutionalism at the international level have often been writers who are making monistic diagnosis or who have monistic ambitions. For example, in the context of international law, there is a large debate which many of you will be acquainted with about there's a fear of fragmentation in international law. You know, there's the Universalism versus fragmentation. The International Law Commission a number of years ago had a report into fragmentation in international law. And on the coattails of that, a lot of people started talking about the importance of resurrecting the general part of of international law. The centre must hold. We cannot have all these different self-contained regimes. But of course, behind that, there's a kind of there's a myth, an illusion. There's the idea that at some point international law had some kind of monistic authority, and it's lost that. But of course, what's actually happened is that international law has developed, you know, in fantastic ways over the last 50 or 60 years. What is called fragmentation, a better word for it is actually development. What's happened is that many, many specific treaty regimes have developed in all sorts of areas, whether it be climate change, whether it be fisheries, whether it be the law of seas, whether it be human rights, etc., etc. You know, and because of that busy traffic, yes, there is fragmentation, if that's what you want to call it. If you want to call busy traffic, if you want to call normative development fragmentation, then you can do so. But one of the dangers is that the language of constitutionalism there is used as a way of kind of trying to reassert the authority of the centre. But in a context where the reality of diversity that it's dealing with is actually a much thicker, a much denser normative reality than we had 50 or 60 years ago. So there's a kind of, you know, there's a kind of nostalgic inflexibility built into that very idea of international constitutional law in that context. So there is some worry that this idea that somehow there's no danger of monism in constitutionalism at the international level. It's not true, because quite a lot of the constitutional literature is monistic. It may be hubristically monistic, it may fail, but it has that kind of monistic ambition. The second difficulty associated with constitutional pluralism at the global level has to do with the problem of plurality rather than pluralism. And this seems in many ways a more palpable, a more obvious problem. This is the one which takes fragmentation seriously and says, you know, if you have so many different kinds of regimes at the international level, you know, how do they ever speak to each other? If they're not regionally concentrated, if they're not concentrated in a single political project in a way which is true of the European Union, for example, what actually are the terms of trade between these different sorts of polities? And in what sense can these terms of trade be thought of in constitutional terms? And of course there, these are very, very difficult questions. There are many different people who have, with very, very different sorts of theoretical frameworks, who have tried to trace the particularity, the fragmentation of constitutionalism at the transnational level. So alongside those who think about it monistically, there are those who think about it in this more policy, in this more sector-specific, in this more fragmented way. And they range from fairly orthodox international lawyers like Anne Peters, for example, who talks about there being treaty constitutions in different sorts of areas, whether it be climate change or development or whatever, and the development of some notion of constitutionality in these areas, maybe the development of courts, the development of erga omnes obligations, etc., that kind of stuff, to more theoretical, sophisticated treatments such as that associated with Günther Teubner and his notion of societal constitutionalism, where his point is that, to put it very, very briefly, at the global level, the kind of fragmentation that we're taking place takes us beyond the very idea of a political constitution. if a political constitution is understood as being a constitution for politics holistically conceived. His point is that what we have now are all sorts of different constitutions. We have a constitution for cyberspace, we have a constitution for sport, we have a constitution for all sorts of different areas, each of which has its own functional logic, each of which is not, for each of which the juridical register isn't even necessarily the most important. But his point is that many of these areas are constituting themselves, they're conceiving themselves in terms of a different kind of, in terms of a particular constitutional logic. But the links and the links between these different constitutional logics are quite difficult to find. So what you find in this literature is there any pluralistic sense in this literature? Is there any sense of pluralism? Is there any sense that the constitutional parts recognize each other? Is there any sense in which we can think of them as having any kind of integrity? Well, there is, but it's limited. You know, and in the paper I give 2 or 3 examples of how they might have that integrity. There may be common normative standards. For example, there may be a recognition of universal human rights standards in different areas. That would be one possibility. Another possibility, which a writer like Nico Krish would point to, is a kind of notion of pluralist mutual accommodation, that these different sorts of areas, you know, if even only for strategic reasons, often accommodate each other in a way which is less monistic, which is less myopic, which is more open to the possibility that other areas of the law might have the right answer, etc. And then, of course, the other way, which Teubner talks about, which is very interesting, is to say that in some ways, if you look at something like the constitution of cyberspace or any other particular area, what you actually have by deep analogy, mutatis mutandis, is a kind of recreation of the same kind of normative logic associated with internal versus external sovereignty. So in the context of the state, you know, what we're doing is that we're always trying to find an accommodation between inclusion and exclusion, between autonomy and over-penetration. We say to the people, you can be autonomous in this area, but don't penetrate beyond that area because that will interfere in other people's autonomy. In many areas, in many sectoral areas of constitutionalism, once constitutionalism becomes more functionally specific, then arguably you're saying the same thing, but you're no longer saying it about peoples, you're saying it about functional practices. You know, the different areas, that the internet, the regulation of the internet should have a degree of autonomy. The regulation of commerce should have a degree of autonomy, etc., etc. And there should be some kind of accommodation between them, which in many ways is the modern equivalent or the postmodern equivalent of the accommodation between sovereigns under the old rule of mutual exclusivity. So that's another way of thinking about this, but again, it's very tenuous, and it's a long way from the kind of constitutional pluralism within the European theatre, where what you had were Supreme Courts or apex courts actually effectively engaging discursively with each other. What we have instead here are people looking at something which looks far more random, far more disorganized, and trying to somehow see some kind of constitutional normativity within it, but in a much more chaotic, a much more disorganized field. And of course that takes us to another criticism, which again, to mention the name of Nico Krish, who is to say that, to make the criticism that that perhaps, you know, that if you are talking about accommodation between different parts of a transnationally plural order, and I'm sure Per would agree with this as well, that actually the constitutional language gets in the way of it. You know, that the constitutional language cannot help, you know, but have that kind of foundationalist drag, that idea of supremacy, that idea of the closed system, that idea of not negotiating with the other. And actually, if you want to try to make sense of global law in pluralistic terms, perhaps the constitutional label should be dropped entirely. So, very, very briefly, constitutional pluralism at the global level sees new sorts of challenges, right? There's a challenge of the new type of constitutional monism. There's a challenge of constitutional fragmentation. And of course, the monism, ironically, is a reaction to the fragmentation. But then again, what you get are this terrible sort of negative symbiosis of these two different trends within constitutionalism. The trend towards particularity and the trend towards universalism, okay? And that in turn leads other people to say that if you're trying to make sense of pluralism at the global level, then it's probably best or better to drop the language of constitutionalism entirely. So I've only got 2 minutes left, I think, of these 5 minutes. That's taking account of these noises in the background. Yep, okay. Could we have some more noises, please? I'll just talk through the noises, but take the extra time anyway. But what I want to say in the end is that where does that leave the language of constitutional pluralism in the global context? I have views on this. I do not have strong views. By that, I don't mean that I'm indecisive. I just mean that I think there's, and this is a point I've made in a lot of my other work, I think there is a kind of marketplace, there's a symbolic marketplace of legal ideas out there, you know, and there's no fact of the matter. There are just different ways of reimagining the legal world, and the question we have to ask is, does the constitutional way of continuing to imagine or imagining a new legal world, does it have better payoffs epistemically in terms of understanding the world, symbolically in terms of legitimating the world, normatively in terms of keeping open the possibility that what frames the world and what drives the political world are normatively attractive ideas. So whether and to what extent constitutionalism can do this is the point I make in the final section of the paper, is that there's a sense in which constitutionalism has lost its hinge. Okay? The constitutionalism used to be about, you know, the idea of constituent power, the authority of the people, and it also used to be about all its particular formations, the toolkit of ideas, separation of powers, universal rights, federalism, etc., subsidiarity, all the normatively suggestive concepts associated with this. But there was always a hinge between the doctrinal and the imagination. And the point I make at the end of the paper is that we've lost that hinge. So on the one hand, we have constitutional bricolage. We have all sorts of constitutional fragments. We have constitutional language used all over the place about rights, about federalism, about all sorts of constitutional fragments. And we also have a vast constitutional imaginary, you know, where people use constitutional language almost as a kind of pre-legal way of thinking about the normativity of the world. Matthias Kuhn, for example, who was here last year, I think, you know, reserves the notion of constitutionalism for a kind of meta-legal language of freedom and equality. Okay? So what you get is, as I say, constitutionalism flies very high and it flies very low. And it's lost that hinge between these two different sorts of levels. And that's something I would say, I think there is something diagnostically true about that. Now, that doesn't lead me necessarily to say, you know, it's not up to me anyway to get rid of the language of constitutionalism. It's there, it will continue to be used. We have to recognize it's being used at these two different sorts of levels. And the questions we have to ask is that, does it continue to have a normative and an epistemic payoff? Does it help us make sense of the world? Does it help us understand what we may have gained and what we might be losing through different sorts of processes of globalization? I think there's a lot can be said for that constitutional language. I think it still does allow us, both at the detailed level, even though it flies low and it flies high, you know, there is something, it does make a contribution, both at the high level and the low level. Different kind of contribution. It's no longer the structuring discourse of the global in the way it was when under the old Westphalian system of mutually exclusive polities. But it's a different kind of, it makes a different kind of contribution. So let me just leave it at that at the moment, and pass over to Per to make some critical remarks, and then I can talk some more if necessary about aspects of the paper. Okay.
Thank you, Professor Walker. Professor Zumbansen.
Do you want? Will I pass this over? Or what? No,
I think the microphone here
you've
is-
got them. Yep. Okay.
That works fine?
No. Go. Don't you just take that? You could put yours on stride.
Sure. No stride. Okay, thanks very much, Neil, for your paper. So, two parts. First part, I'd like us all perhaps to just reflect for a minute or two on the nature of the paper you just heard. And that's important because I think the paper that we just heard and the paper that was distributed is really quite a good example of what scholarship can be, and it also suggests what it often isn't. So, but what it should be. So, the paper. You see, that's the German trying to be ironic. Very good, yeah. We're known to do that really well. So, what I'm trying to say in my Germanically subtle ways is that this is actually a very, very good example of how you have to map a debate in order to make it really difficult for people to just jump at one or the other point in your paper and say, I disagree with that. And that, I want to highlight this for a second because it's not only relevant for people in early stages of their career, where once you've gained some kind of mastery of a particular field and you know a little who the players seem to be, and then you take sides. But it takes, in fact, a lot of effort to construct and to paint a landscape that, as you see so many publications coming and going and feeling more and more anxious of how to keep track of all of these things and all these people with their different interventions, it takes a lot of effort and some patience, and that I want to highlight because it's so important to do that. But it's not only important at your early career stage, but also, as you just saw, at a stage where so many people talk about a small set of terms, and they all mean different things. And so in order to make sure that you get your message across, if you map a debate first, then you will have a much more alert audience around you. And also the important thing is that you then have to really know what the others are saying. And that's why it's so important to have a map. That's really a really crucial point. And what you just saw is relatively impressive, because Neil Walker doesn't even have the paper with him. Well, there it is, yes, but he didn't even open it once. So he painted that map just off the cuff now again. And you can only do this if you really know what's at stake in that map. Good, first remark. Now, the second remark is going to be a bit more daring, perhaps, and challenging, and not so just to say how wonderful all of this is, but in fact how wonderful it is, but that we might want to contextualize it a little further. So part of this project is to show that there's a chronology that we have to take into account when we want to understand where this debate came from. And that chronology is not just merely a question of time, but it's also a question of place, and that's really important here. So yes, for Neil Walker and some colleagues in this debate, the European experience is really quite important. And again, for us as people trying to understand where all of this comes from, that's really important. So let's say we are non-Europeanists, we are just transnationalists or globalists, and we come to these highly contentious debates in international law relatively recently. We might almost want to skip the first 10 pages because we say, well, what do we care? No? But in fact, there's a big lesson to be learned. So one is that it might be really important to understand the context in which people start to think about what a constitution is and why they might want to drop the term in favor of adopting a more fluid terminology, which is constitutionalism. In this case, it might be partly the European experience, but there's also other things that I want to suggest in a second. But that European experience is important because it has held scholars and citizens and practitioners captured for a long, long time, and it will continue to do that for a little more time at least. And it does that because it is in fact a really fascinating example of what transnational governance actually is. No? That's why nobody knows how to define properly the constitutional nature of the European Union, because it is in between so many concepts that we know. So it's partly intergovernmental, it's partly supranational, it's partly federal, it's partly still, and that's really the emphasis on the intergovernmental part, it's partly still very much focused on individual countries, but then it's also, from a more comprehensive point of view, it's also an extremely powerful illustration of a global governance regime. And then in economic and political economy terms, it's also an extremely relevant cluster of a powerful market actor. Okay, so all of these things figure prominently in the genesis of why people in Europe became so interested in constitutionalism. Okay, now, see, most of this isn't there anymore. No? Now we seem to have moved on. So we now talk about constitutionalism not in an abstract way, but some of the experiences and some of the really tricky things about European integration are only referenced here now. But they're no longer fully engaged with, because that might have passed. Okay, so that's one of the legacies of this. So as we then move into the next phase, which is the non-European or post-European phase, that seems to link really well with the post-national space in which we now want to talk about constitutionalism. And that, I think, is tricky, and that's the only real, comment I would like to make that we might want to reflect on a little more, which is how persuasive is it really to distinguish that world of the nation state and constitutional ideas that are tied to that state and the world outside. So one of the easy consequences we might draw from such a distinction is that we lose certain certainties and we lose certain institutional structures and also structural formations such as unity of law and a hierarchy of norms, all of these things which we associate with the nation state. So as we move into a space that has a much more fragmented, much more volatile and fragile cluster of political authority, different sides of polity, as Neil said, it seems almost obvious that as a public lawyer, and that's the other legacy that Neil has, as a public lawyer, that one constates a fear of loss. So there is a fear that we might not be able anymore to apply the same mechanisms and terminologies and also structural understandings that we used to. Now, as a private lawyer, that has never been convincing. So
that's your legacy.
It's just the other side of this. So this description makes a lot of sense if we adopt a public law perception, and that's also really quite relevant if you come from a European context. Here, it's all intermingled now, but the distinction in Europe is really quite relevant still. If you are a public lawyer, then you never get hired as a private law teaching person anywhere. No, you're a public lawyer forever. The only thing that's really intriguing about this weird system is that nobody knows what European law is. Is that market law? Then it would just be private. Or is it public law? Then it would be predominantly about constitutional law and administrative law. Now, as a public lawyer, one tends to associate political authority, hierarchy of norms, and a clearly structured landscape of who exercises this authority with the term of constitutions. But private lawyers don't think that way, and that's an important challenge in this moment where we move into this transnational world. We move into this transnational world, and now we're being asked to consider what the fate is of the institutional framework and normative framework that we used to have. And it's all about trying to save parts, reinvent them, and now we shouldn't reinvent them. And that's of course totally adequate. Now, why am I pushing this private law perspective so much? Because private lawyers think about about the constituting quality of normative arrangements, and that people will either agree on something or that they will try to find consensus among several people, that they will try to put in place a process as a constitutionalizing process. And they don't take for granted that there is a constitution. Of course, there's this whole world in private law that is very Hayekian and law and economics influence, and that will take for granted that there's private ordering, but that all takes place in the shadow and with the safeguard that there is the state and some legal system that will always protect it. But if you take private law literally, you will never be able to rest comforted by the fact that there is a constitutional framework. In fact, in a very radical liberal understanding of what private law is, the connotation of private as coined in distinction from public doesn't make sense anymore. In fact, a private lawyer just thinks about law. And so if you just think about law, then you don't have that fear of loss. You have that fear of how to generate. And then you can draw on experiences. So what are the modernist aspirations of which this paper speaks so much? And that some people find really worrisome because they will perhaps be exported in an imperializing way. You know, those are some of the worries by Nico Krisch, for example. But as a private lawyer, we imagine that there is no constitutional framework yet, but that we don't know whether criminal law is not just as constitutional, whether environmental law is not just as constitutional because it creates sustainability, for example. So private lawyers would think about this a bit differently. Now, I want to draw your attention to the piece that Neil Walker mentioned from a few years ago, where the language is still very much different and much more what a private lawyer would use. So in that 2002 piece on constitutional pluralism, he says, conceptually it is argued that in order to capture the full range of the constitutional experience and imagine the full range of constitutional possibilities within the new plural order, constitutionalism and constitutionalization should be conceived of not in black and white, all or nothing terms, but as questions of nuance and gradation. That is important because it points to the dynamics. So the present paper makes very, very helpful distinctions, and it helps us very much understand where people come from and what their aspirations are as they mobilize particular understandings of constitution and constitutionalism. But it petrifies these positions. No, or at least it might carry the risk of doing so. By putting these people that have these particular skepticisms into these camps, we might not be able to understand so well of how they all have to acknowledge that constitutionalism keeps changing all the time. So there's a very inherent dynamic to constitutionalism. And that's even stronger just on the next page. That is to say, as already intimated, constitutionalism in a plural order is necessarily conceived of not only as a property of polities and political processes, but as a medium through which they interconnect, as a structural characteristic of the relationship between certain types of political authority or claims to authority situated at different sites on different processes, as well as an internal characteristic of these authoritative claims. Now, the world in which we all study constitutional pluralism now seems to be divided into people that work on global constitutionalism. It's almost a self-standing term. Now, you can make a career in this. And that term seems to be capturing those people that are more interested in at least still struggling with normativity. On the other side, you have global governance people. And global governance people are supposedly those that find that the constitutionalism project is too ambitious. You see, and that distinction, of course, is nonsense. But that's the distinction we all perceive now, because that's how scholars camp themselves. Now, if you take a step back, and whether you want to call it private law approach or just law as law, then you might say that these global governance parts are always part of thinking about the constitutional dimensions of law, because you have to think about processes. You have to talk about exclusion, inclusion. Private lawyers very early on talked about proceduralization, and it's really crucial. That's the last example I will give. It's really crucial to goûter for a second what that means. If a public lawyer proceduralizes, then it's all about granting greater access, for example, of people that will be exposed to some administrative decision at some point. But that always takes for granted that you have that framework. There is a regulatory agency, there's administrative law, and if it all goes wrong, you have a constitutional claim. A private lawyer proceduralizes without any of these safeguards. Private law proceduralizes constitutionalizing process because they have no safeguard. They have to be radically open. And that's exactly why constitutionalism and global governance shouldn't be set apart, and why it's good to have these skepticisms, but why I would say that Neil should not forget that this was more daring and more private law, Aiken, than, to give so much room to these relatively, I don't know, they're not that strong, these skepticisms.
Thank you very much, Ben. So, a few minutes and then we'll open the conversation to the floor. So if you have rejoinders or thoughts. Microphone.
Right. I think I agree. Yeah, I mean, I think, can I, it's interesting. I mean, one of the things I said in that original 2002 paper was that there was what I called a public institutional bias in constitutional thinking. I was talking about the framework, the received framework of constitutionalism. And one of the things I was critical of, I remember Günther Teubner being pleased that I was critical of it, was the public institutional bias. And one of the interesting things that's happened since then is that I think the creative thing which has happened is that those people who are having this debate in a serious and engaged way, rather than just trying to score points, and I hope that I'm one of them, and I know that Per is another, are actually looking not to turn constitutionalism into a hurrah word or a boo word, but just to look at what it's trying to get at. What is it? We were talking about David Kennedy's article, "The Mystery of Global Governance." Where he says, that beneath the language, there's so much we just don't understand, we don't get about global governance. It's a field that the practice outstrips theory in such a radical way, and constantly we're trying to catch up, to make sense of it, to normativize it, etc., etc. And I think one of the interesting things is to try to find a common language of normativity which is not biased in favour of either the traditions of public law or the traditions of private law, okay? But which somehow answers to the expectations and the genuine insights of both. And I actually think, although this paper might seem, less daring, whatever, one of the things I'm trying to do is to acknowledge the fact that some of that development has actually taken place. So people like, a number of people, Per does it in his own work, but I concentrate here on Teubner and to some extent Nico Krish, who actually are trying to do that kind of translation exercise, So Krish says, in his work, he said, look, he said, I'm intrigued by the notion of public autonomy, which you find in Habermas. And Habermas is hardly mentioned in this paper, but just. Am I allowed to do a 2-minute tutorial on Habermas here? Just 2 minutes.
2 minutes. 2 minutes.
Okay. So Habermas talks about he talks about symbiosis of public autonomy and private autonomy. So public autonomy is the sphere of the political and voting and creating the sphere of collective solidarity and self-consciousness, etc. Private autonomy is about the freedoms, you know, which you cherish in terms of your liberty, your property, etc., etc., your capacities to live an autonomous life. And of course, his point is that these are, rather than being oppositional, these are both valuable in their own right. Okay, so they're normatively valuable in their own right, each of them. You know, it's not that one has to win the battle of which is normatively valuable, but also that they are they're mutually causative. Okay, that in some idealization of the state world, public autonomy is the best way. A healthy sphere of public autonomy is the best way of protecting private autonomy. But private autonomy is also necessary to have citizens with the wherewithal, confidence, knowledge, etc., etc., to protect public autonomy. Okay, so that is a theory of, which is often seen as a theory of publicness, which is actually as much about privateness. You know, and that to me is a vitally important lesson to learn. You know, that what you have there is a way of understanding the public and the private within a particular institutional architecture revolved around the state. You know, and the question we have to ask ourselves is that the institutional architecture has changed. Maybe architecture is too static a word for what we have now. You know, there's a fluidity of process, but these ideas, the idea of there being a sphere of collective decision making and a sphere of individual autonomy, are just as important as they were, and the way in which they relate to each other might be different. You know, and many of the spheres of collective autonomy now might be very, very functionally specific. They may be epistemic communities more than they are broader political communities. Many of the forms of autonomy we're talking about, we're having to re-aggregate autonomy from different parts. You know, these things are changing, but the values associated with them remain very, very important. And I think if constitutionalism was always as interested in the private as it was in the public, and I don't think there's any reason to say that it wasn't, right? You know, I mean, only a certain type of myopic constitutional lawyer didn't realize that. Then, you know, I don't think it's necessarily an inappropriate language. And that indeed is one of the reasons why Teubner takes the language. He takes the language of constitutionalism because he thinks the idea of something being constitutive is an incredibly important metaphor for getting at both collective autonomy and private autonomy. But the way in which we do that changes between different phases. So I think I agree, but that's me agreeing.
Okay, let's seize this opportunity to open the discussion to the floor.
Oh, okay, just talking about like...
You will need to have the microphone, so do we have an extra microphone? Or? Okay, let's just make sure we circulate the microphone, that you have it before you speak. Thank you.
Just to slow you down.
Exactly.
No problem. Wow, I learned quite a bit about constitutionalism, but as like a person interested in like sociology and political science, talking about public and private autonomy, I read the piece by, I think it was 1992, by Nancy Fraser, and she critiques Habermas's communicative theory because, well, what you were talking about, how practice outstrips theory, that historically, well, who inhabited these spaces of what I think she refers to as democratic? It was white males, and it was quite an exclusive club, like women and racialized peoples were not considered as being part of that public space. So I guess that could be a way to start to look at the ways in which there is this disconnection between what we're learning and what is actually happening on the ground. But relating it back to public and private autonomy, what would you say in terms of constitutionalization? Like, was there, or constitutionalism, sorry. Did you find that in your own research, that there were certain discrimination or exclusion from certain bodies or people more generally being able to participate democratically in a public space?
Yeah. Yeah, I mean, I think undeniably, I mean, I don't think, there is a sense in which, and I'm sure Per has something to say here as well, that one of the interesting things that's happened in the left in the last 10, 15 years is a kind of slightly statist golden age nostalgia. You know, that there was a time of public autonomy and private autonomy where they wrapped around each other in felicitous ways, and couldn't we please go back to that? Yeah. And of course, you know, first of all, empirically, that wasn't the case. Of course not. It's not that it was better and worse. You know, there were better examples and there were worse examples. Of course there are. You know, this is too big a thing to be a good thing or a bad thing. You know, it's a frame, and some of the things within the frame were awful and some weren't. And of course, there are dangers within that way of framing the world as well. Of course there are. You know, that one of the classic criticisms of Habermas, which isn't just a criticism of the Habermas, it's a criticism of that particular conception of the state, is that there's a sense in which the stakes are too high. You know, that everything turns upon the way in which public autonomy is developed. Everything turns upon often the path dependence of whose private autonomy is protected, etc., etc. And of course, and again, I think this is something that Per would say, that in many ways, the global didn't come from Mars. The global came from us. You know, the global coexists with the national, and often the global is a set of responses. You know, either progressive responses, you know, to the so international human rights is part of the global. Okay. And that's an attempt, you know, to break the umbilical cord between the state and the protection of the fundamental rights of the subject in ways which are problematic, but has a positive side. But also, the Washington Consensus and the global development of economic rights is also something, which comes from us, or from some of us, you know. And in that sense, what that is that's breaking something which is positive in the context of the state, or can be seen as positive in the context of the state. It's breaking the possibility of, you know, of a kind of fiscal control which makes a certain type of national welfare state possible. Ask the Greeks today. You know, it's so these things, you know, I don't think it's you know, what we're talking about here are very, very abstract structures. I think the Habermasian theory doesn't necessarily, I intentionally didn't mention his communicative rationality here. Yeah, I didn't mention, you know, you don't have, it doesn't have to be, you know, you can buy a lot of Habermas and not buy the discourse theory, you know. The Habermas is just a Kantian, you know, with a bit of discourse added, yeah. And a lot of what he has to say, you know, depends upon your own sense of the healthy possibilities of democracy. The healthy possibilities of democracy do not necessarily have to be seen through the communicative ethics lens. But, you know, so, yeah.
I'm not asking a question, just a clarification. I agree with you about, you know, that we actually create like globalization in some ways, that it's not just something from Mars. And that this is something historical as well, because there is a lot of white industrial mill workforces in terms of being provided by the state with pensions, wages, working conditions, and then of course the exclusions, which were briefly talked about. So thank you.
Okay.
You may want to remove the microphone from its base and just circulate that. There we go.
Okay, thank you so much for the paper. I haven't read the paper, let me confess, but just from listening to you, I have a couple of issues or perhaps some comments. Now, maybe tied to what he said, the issue of legitimacy. Because when you look at even within the domestic legal order, you already have issues with the Constitution being seen as a ground norm, because you already have, because of the fact that it is exclusive, you have margins of people who think, okay, it is not legitimate. But when you now take it to the global order, wouldn't you think that the issue of legitimacy will become more pronounced? That's the first question. But also that, and this is, in Europe, considering that this is, this has the history behind it, it's from Europe. When you take it to a global order where you already see this fragmentation, especially when you mention about international law, to talk about global constitutional pluralism at the global order, I feel like it's a bit more problematic when you talk about the issues of legitimacy. And also tied to the fact that theoretically, while you can say that in terms of these constitutional orders all coming in, not one will trump the other, when we know that in practice, if we look at the power dynamics that play at the global level, when you now take an issue, or when you now start talking about constitutional pluralism at the global level, isn't it a bit naive, let me use that word, to say that one constitutional order or legal order won't trump the other? That one constitutional legal order won't trump another one, in terms of power dynamics and the kind of things that can happen at the global level.
I think, the thing about trumping, the point is that in a European context, you can actually ask the trumping question, intelligently, because there is a question. You can say, okay, so here's the German Constitutional Court, here's the European Court of Justice, here's some normative possibilities, here's who gets the last word, here's who prevails. Often in the global context, the kind of relationship you're talking about is very uneven, very unstructured, very untidy. You might be talking about the relationship between, say, a human rights regime and a developmental regime, or a climate change regime, or a law of the sea regime, or whatever it might be. And who trumps who? There isn't a structured context within which you can necessarily ask that question. It maybe depends upon the issue. It depends upon which court the person goes to. It depends upon what processes it went through. And then, of course, which I also think is implicit in your question, it also depends upon the power structures underpinning that. Because often it's people can win victories in courts, but they're Pyrrhic victories. Because actually certain other orthodoxies of power are prevailing in different sorts of ways. So, yeah, I think we should, on the one hand, probably avoid the language of trumping, because it's too fixed a legalistic language to see what's going on. On the other hand, I entirely agree with you. We have to be aware of the fact that, diversity in the world is also asymmetry. It's not diversity. It's not power equality in diversity. It's diversity with significant asymmetry. Can I make one point about the use of constitutional language, etc.? One of the reasons, it's not a throwaway comment to say that, we're not, what is it the Académie Française, we don't get to choose the lexicon. We don't get to choose it. It's there.
Neither do they.
Well, exactly. Exactly. But yeah, fine. Actually, an even better example. Just like the Académie Française, we do not get to choose the words that people actually use. You do not create meaning by theoretical diktat. You don't. You might influence it, probably in ways that you don't even realise, but you don't create that meaning. So we're stuck with terminology. And if terminology fades out, it's because it stops having any kind of practical traction. It's not because we decide that it's not interesting or useful anymore. So, for example, take administrative law. Here's a term. So some people say administrative law has no traction in the modern world. Then people come along and start talking about global administrative law, and suddenly it's reinvented as an idea with different sorts of possibilities. Take the rule of law, the notion of the international rule of law. The very idea of the rule of law, in many cases, was a discredited idea, because it was seen as one of the ways in which the West imposed a certain type of order on the rest of the world. in particular the Global South. There's an interesting rule of law discourse now which isn't so much like that. Because what happens often, there's almost like a natural countervailing influence in the use of key terms. You know, that if it is used in a hegemonic way, then people will find counter-hegemonic ways of using the same terminology. So often constitutionalism is actually used as a very, very critical term. It's not used. I once wrote a paper about the use of constitutional language in the WTO, because lots of people said, don't let them use the language of constitutionalism to dignify what's happening in the WTO. And my reaction to that was, well, actually, you know, people who use that language are not in charge of the consequences of the use of that language, because once you actually start raising expectations, you know, about if people start saying the WTO is a constitutional order, someone says, okay, let's have some of the things that we have within a constitutional order then, like a bit of democracy, a bit of voice, protection of a wider range of rights, etc., etc. So the language we're talking about, you know, may be used in naive ways, it may be used in cynical ways, in self-interested ways, but usually that creates the very dynamic out of which other sorts of uses develop as well.
Okay, I have a question, Neil. I thought that was a very thought-provoking paper. Now, you seem to say that that language, the language of constitution, constituent, constitutionalism, is a good, at the end of the paper, you say, conceptual point of departure to understand what is going on in the world, that global legal order. Now, when I think about that language, constitution, constitutionalism, constituent, I tend to think, well, what does it constitute? Right? What does it? What is the subject of that discussion? Historically, modernity, as you pointed out, took the state as being the focus of that discussion. Right? We're trying to understand what the state is. Now, it's unclear in these discussions that you're talking about what that focus is. Right? What is it? Is the global polity, you said? Some people say it's a global order. Some people seem to say, well, it's a set of norms which are akin to political morality as understood in a more cosmopolitan way. It seems to me that in the context of discussions about the state, we've seen a phenomenon unfold, which is that a lot of people said, well, the state is too difficult to understand. We're going to stop talking about this, and we're going to move to this discussion of constitution, which is more narrow because it brings with it a set of assumptions, baggage, tends to be about law, tends to be about a certain set of values. So we have a lot of people working on constitutional theory, not so many people working anymore on what the state is. You have the odd person who brings in the new theory and insight, but not that many people. Now I'm wondering if a similar move is being made here. Let's just move from all these disparate phenomena and move to the discourse of constitutionalism, which comes with a certain set of with a certain baggage, such that we have something to discuss and seemingly allow us to have discourses together about this, forgetting in a sense to the importance of trying to delineate what the actual phenomenon is in the first place. And you make that leap yourself. At the end you say, of your talk, you say that there's really a symbolic marketplace of ideas to represent our legal world. And that's what constitutionalism and constituent and all these things, these words go towards. I would say, well, that's a very strong assumption, right? Even if you think about, let's think about the case of the state might not be just legal, right? Kelsen taught the state is the law, right? But there are all sorts of other norms. Let's just talk about, in very Canadian terms, of constitutional conventions that are not law, right? That's also part of that phenomenon. And so I'm wondering whether you're trying to legitimize this kind of shortcut, saying, well, let's focus on that other term, as opposed to try to agree on what this moving target is, right? I don't know if I'm making myself clear here, but it seems that there's a big tension here that people are trying to, get rid of by invoking that unifying language, as it were.
Yeah, I think, where do I use the term legal? Sorry.
No, in your speech you said that ways of representing the legal world, and I thought that's interesting.
I need a lawyer. I think right. Okay. I don't hold to some two things. I don't hold to some narrow sense of the of the legal, right? Nor do I hold to a sense of the legal as somehow being constitutive of everything else. You know, what I'm interested in is steering capacity. You know, is wherever you're going to find that steering capacity. Okay, so if I said the legal, then there is a slip there. Okay, because because at the end of the day, the legal never has much steering capacity on its own. You know, that's one thing that Toynbee is very good at getting. Saying, look, the effectivity of practice, you know, is always the result of a number of different registers coming together. You know, and there'll be an economic register, there'll be a legal register, there'll be a political register, etc., etc. So I'm interested in, you know, the law is in there somewhere in all of this, but it's not necessarily taking the lead. Your point about what is it that we're trying to grasp here, and are we overreaching? I think it's a good point, because I wrote a paper in ICON a few years ago called the Disorder of Orders, which is saying that, and the thesis of that paper was that something ironic has happened in our global legal language, which is that people have started angsting. There's much more anxiety about the ordering of orders, right? Okay. In itself, that's a kind of ironic consequence of globalization. So people start thinking about this. How does that authority system fit in with that kind of authority system, etc., etc. So there's this anxiety associated with it. Okay. At the same time as a lot of the orthodoxies associated with certain legal discourses are brought into doubt. So constitutionalism, you might say that constitutionalism is something that, as the power of the state is hollowed out, then that should create a certain type of constitutionalism anxiety, because those people who thought that constitutionalism was a good way of thinking about the authority of the state suddenly realise the state isn't quite such an important actor in the same ways, etc., etc. So it creates a degree of anxiety. It also creates at the same time a greater awareness of the fragility, the contingency, the vulnerability of the way in which we make our orders. You think, okay, so actually, you know, that nice picture of the world, constitutional law, international law, etc., it was never a nice picture. It's actually a very vulnerable picture. It's a very fragile picture. Now, one of the ways in which people have reacted to that is actually by using the old language, which has been displaced from its position as a comfortable part of the overall understanding, and try to turn it into a kind of general understanding. So constitutional lawyers invade the area that international law used to operate in. International lawyers invade the area that constitutional lawyers used to operate in. Private lawyers invade the area that constitutional lawyers used to operate in. Administrative lawyers invade everything. People come along with ideas of jus gentium, which they rescue from the 16th century, and say it's all about that. So there's this kind of hyperinflation within that marketplace. Okay, and people now, what do we say about that? You know, is it a Tower of Babel? What's going on there? What is going on there? So there is an irony that because something is no longer so confidently located within a particular place, within a discursive world, it actually expands beyond that. Now, I think all I can say is that we have to be aware of that, right? We have to be aware of that. And we have to be aware of the fact that there will be contending languages and there will be contending discourses. I tend to think that, I think it's an interesting fact about the symbolic world that the language of constitutionalism has not died out in the last 20 years. It's become more expansive. I think that's an interesting fact about the legal symbolic world. You know, and it's both a sinister fact and a hopeful fact at the same time. And it probably has colonized more space than some of these other terms. You know, and it's colonized more space precisely because of that vulnerability, flexibility, the fact that things are being loosened up. And I think we have to accept that. you know, we have to be aware of it and develop the language accordingly.
Thank you. My question is about the transnational capitalist class. I was at a conference 2 weeks ago, and Professor Chimney, Bhupinder Chimney from India, articulated this idea of a transnational capitalist class that is basically fueling a lot of the internationalization within what's going on right now. I think he wrote a piece in 2004 that appeared in the European Journal of International Law, where he first articulated that idea. And now he gave a keynote at Oregon, which will appear in the Oregon Journal of International Law. And basically the idea is that there's a particular capitalist class that moves along creating these spaces, which captures particular spaces. And I'm wondering how the language of constitutionalism ties into that capitalist class, which I think we're all part of to some extent. Because if you ask my friends who are defense lawyers at the International Criminal Tribunals, for example, they'd probably laugh and say there's no constitutionalism going on here within the ICTY or ICTR because the judges are, you know, appointed in a particular way. They don't have legal education, they don't have particular backgrounds, or they don't have the relevant backgrounds. So I'm wondering, how does that all fit into this whole claim?
So what was, could you just clarify what's the relationship between the international capitalist class
well,
and
I
these
think that
guys
there is
not having a legal background?
Well, I think there's a clear capture by the class that moves around, right? In terms of how judges are appointed, in terms of how the system functions itself.
I'd have thought if they had a legal background, that would make them more likely to be part of the capitalist class. But
Right, but, you know, exactly, but that's just an example of it, right? Or,
well, yeah, but it seems to be an example that you win both ways.
well, really? Because it depends on if you're the accused, right? Because, you know, in that particular context, if you're not getting the right kind of decision being made, you know, if a particular judge is sitting on the appellate chamber who doesn't have a right understanding of evidence, for example.
Yeah.
And so how does that play out in terms of this conceptualization of constitutionalism?
And what did we have before we had the international tribunals?
Nothing.
Yeah. Impunity, yeah. I mean, I think the problem about internationalization is that there are so many vectors of internationalization. You know, the Occupy movement is an international movement. You know, the Occupy movement is as much about globalization as the international capitalist class. It's partly a reaction to it, but not just. It's also about a different use of global communicative possibilities. It's about a different use of global political possibilities. It's about a different use of the fact that there's a global culture in so many different sorts of areas. It's about a different use of the fact that people understand that transnational power is now viral. It's interesting. 10 years ago, people didn't understand this. 10 years ago, if you were talking about, when people were trying to piece together what happened in some of the anti-globalization marches, events, etc., whether it would be G8 in Genoa or wherever. Often, people were piecing this together from the outside. No one does that anymore. People piece it together from the inside. There's a very clear sense of there being a degree of organization. Organization is actually an old-fashioned word, but there's a kind of networking aspect to the way that we understand these things now, which has changed. So yes, you know, look, my sense of this, you know, where we get into very, very broad debates here is, and I'd like to hear what Pierre has to say, but, you know, let's not be naive about globalization, in either in the sense that globalization is, you know, globalization is many things. Also, globalization comes in many, many waves. You know, one of the interesting features of contemporary globalization is that it comes with a high degree of self-awareness. You know, globalization is something we understand as globalization. That never happened before. So there's that kind of reflexive self-understanding of globalization as globalization. And of course, globalization is you know, Anthony Giddens once made the point, said that, you know, we didn't have a language of fundamentalism before we had globalization. And the point he had to make was it wasn't that people didn't have strong, resolute beliefs, which would be deaf to opposite beliefs, which would be part of the definition of fundamentalism. It is that, you know, fundamentalism can only exist when it's in strong and undeniable juxtaposition with other ideas. You know, so the idea of fundamentalism, it's not that fundamentalist views are new, but so that the other side of globalization has always been that globalization is about both the transnationalization of different sorts of economic, cultural, communicative processes and the possibility for homogenization, you know, assimilation which go along with that. But it's also about how that at the same time dramatizes difference. You know, it does these two things simultaneously. It creates new forms of consensus and it dramatizes new forms of difference. So, you know, one thing I would say about global capitalism is that there is probably greater global capital mobility now than there has ever been in any way that you would want to measure that. There's also greater awareness of that than there has ever been. You know, there was no language for the Washington Consensus a century ago. There is now.
Can I add a sentence? Yes, very quickly. It might be two. So when Gretchen walks up to Faust, in the tragedy Faust, and she asks, "What do you think about God?" then she really needs to know an answer, because that will totally explain the world to her. And so if you ask the question, if we ask the question now, so how does this debate of global constitutionalism versus global governance, or global constitutionalism and global governance, how does it relate to decades of capitalist critique? How does it relate? Then that's Gretchen's question. The fact is that he will lie to her, Faust will lie to her, and even if we want to give a positive answer now, it has to be under complex, and that's why. So I like to read. I like to read about the class, and I like to read all of these things much more than I want to read Teubner, who just splits it all up, and you don't know his politics anymore. But the problem is that the time has somehow moved on now from, if you went to say you're against nuclear power and you form a Green Party and you do all of these things, that you can actually change a few things because they're relatively confined yet. Now that's not so possible anymore, because you could very well imagine that to just ask for the standing of trees or to just ask for certain environmental values always has to become much more sophisticated, because it's all part of a regime that you might describe as a governance regime, or you might just rightly describe it as a capitalist regime. But if we took an anti-capitalist stance, it would just be as explicit, which is imprecise, as when we would take an anti-globalization stance. But that doesn't mean, that's why it's so important to engage with that. That doesn't mean that we shouldn't. That theoretically it has to be spelled out in an entirely different way. So that's why it's so important, I think, to mix, or to keep these two strands really connected, not just to think constitutionalism is all about values and about political structures, and global governance is all about, or is much closer to sectoralization and functional differentiation, because the idea about capitalism, or about right and left, about exclusion, inclusion, runs diametrically right through those two debates. But to say there is a capitalist class means nothing. At the same time, it asks the question, what are the politics? And that's why one has to keep it in mind. But so quickly it becomes a relatively under-sophisticated conspiracy, and that doesn't help.
Yes, microphone, please.
Sorry, I'm stepping into the field which is not mine, so I may not be very precise. But first, I want to know whether you draw a distinction between globalization and universalization. I do. I think globalization is the 1% movement, universalization is 99% movement. This is the first thing. And second thing, if I understood correctly, this constitutional pluralism is a Europocentric movement or Europocentric attitude or phenomenon? You think so?
It started off as.
Started there.
Yeah.
So then, so now I want to use the dirty word. So, for example, Gaddafi's attempt to have this unionized Africa, or, for example, the attempts among the Arabs or Iran to have this this unificatory thing. What is the relationship between these two phenomena? Just, if at all, if there is any relationship.
Well, sorry, can you come back to, you said globalization is the 1% movement. What was the 99% movement?
Universalisation.
What's that?
It's the movement of the grassroots. The first one is coercive, the second one is from the grassroots.
What does that mean?
What does that mean? That is against capitalism, that is capitalism.
So who says that globalization is you know,
This is the distinction which is already drawn, it's not mine.
but drawn by whom? You have
I
to
don't
justify your own distinction, sorry.
So to me, any movement which is from the grassroots, from the people on the street, from the people who are being coerced or forced or are in the working class, if you like, or its allies, it's a universalization. But the opposite, like G20, G8 or whatever, that's a globalizatory activity, if you want it.
Yeah, but
I can send you an email and tell you where I read that, because this distinction is already drawn somewhere.
yeah, but it's drawn by someone who draws that distinction. That person doesn't, you know, have any great authority. They just drew that distinction. You know, it's that people use globalization in very, very different sorts of ways.
Yeah.
You know, there's a literature about whether globalization is a dirty word or not. Also, you know, universalization. You know, I'm not sure that universalization is such a wonderful word either.
So what is the name? I'm just thinking about two different phenomena, I think.
No,
But if you-
universalization, but it means that I mean, but it's based upon a certain idea that there is a kind of grassroots momentum which would take in 99% of the population of the world. I think that's a simplification, yeah? You know, I mean, I'm not saying you can't have grassroots movements. You know, I'm not saying the Occupy movement isn't a grassroots movement. I'm not saying it isn't a positive movement. But I think we have to be careful about the terminology that we use. You know, presumably, you know, the grassroots in different cultures have different aims and interests. There is a political movement which can reconcile their interests, but it's not that they naturally have the same interests. Which takes me on to another point, which is, what is the relevance of this Eurocentric debate to, it's a very interesting question, because part of the problem here is that there is a kind of European hegemony over the use of constitutional language. And a lot of interesting things have happened to the use of constitutional language in the last 20, 30 years. For example, the use of constitutional language in South Africa is interesting, and it has not been European-centred in the same way. The use of constitutional language in Latin America is very interesting, because there what you have, Andrew Arato in a recent book on constitutionalism makes the point that that often in the history of constitutionalism we fail to make a very important distinction, which is we tend to distinguish between popular constitutionalism and non-popular constitutionalism. So the constitutionalism of the people and the constitutionalism of the Washington Consensus with their economic rights, whatever. He says there's actually a more important distinction within popular constitutionalism between a kind of quasi-fascistic idea of popular constitutionalism associated with Carl Schmitt, and another notion of popular constitutionalism which is like a kind of learning popular constitutionalism which understands the demos, the people, in a very, very pluralistic way from the outset. Now, part of the tradition of constitutionalism in the Western context was Schmittian. It was. You know, it was based upon a homogeneous notion of the people, etc., etc. And it's one of the, I think the interesting thing, it's been non-Western sources which have been instrumental in moving away from that. Not just, but to some extent at least. I think in the context of Africa, I don't know to what extent constitutional language is used in the context of the Arab Spring. I think it's used in different ways in different places. It has been used incipiently in the context of the Organisation of African Union, hasn't it? Which renamed itself 2 years ago. There's a use of constitutional language creeping into that. You know, but again, the interesting thing is whether that's just aping a certain type of European language or whether it's more transformative. I'm more confident saying that in the South American context it's been more transformative. I'm not sure in the African context. It's a really interesting question.
Thank you. Right. Professor Priya, microphone.
Hi. I have a sort of historical question more than so. The process that we see now in Europe and you focus on. So, would you say that what happened in the history of the United States is somewhat similar? Because I'm not an expert on this, but as far as I know, the United States before the Civil War was much closer to the European Union model of several states that are fairly independent and actually it was the Civil War, what happened afterwards, that created the United States as one country in the way that we think about it today. But the debate is still going on between those who favor state rights and so to the extent that the debate is still there, or to the extent that changes have happened there in the United States, they've happened mostly for kind of political reasons, and not so much the debates among legal scholars, I think, I don't know, was kind of secondary to this. So do you think that ultimately what will determine the fate of pluralism, constitutionalism in the European context will be the same, and perhaps that's an opportunity for you also to discuss what you said before about the current crisis or crises that afflict Europe?
Yeah, I mean, I think it's interesting. I mean, the odd thing, one of the, I mean, you can't keep America out of this story, because, the as in so many areas of our history, the American experience has been incredibly influential, and it's also atypical. So it's that strange combination of atypicality and influence, and that entirely describes, American constitutional history, in all sorts of ways, but, for example, the use of a certain type of popular constitutionalism in the American tradition, was unusual at that time. Not unknown, but it was unusual. But more importantly, it's precisely your understanding of let's call it the federal question, right? Because the orthodox modern view of federalism is that federalism is about 3 levels of power. There's the power of the whole, and there's a power of the federal level, and there's a power of the state level. That's what the orthodox theory of federalism says today. And so, through that you get the polity as the 3rd level of power, negotiating the relationship between the other 2 levels of power. That's how we understand it. That's how we understand federalism. And then we make a distinction between classical federalism and different and cooperative federalism in the German model. Okay. Now, it is entirely a moot point whether that was the self-understanding of the American state between 1787 and 1865. And we understand it retrospectively that way, but it's a classic case of retrospective wisdom. The other understanding of it was there was no 3rd level, right? All there was a negotiation, an ongoing negotiation between the 2 levels. There was states' rights and there was federal rights. And so we say, but how could it be the United States then if there weren't a 3rd level? But that's us using today's understanding to make that retrospective point. I had a student who did a thesis on this fantastic piece of work, which also looked at the German Bund of the early 19th century as an example of the same, where what you had was a kind of 2-level federalism which was not consolidated by a 3rd state level. Now, the somewhat gloomy lesson there is that both of these entities only lasted for 50 or 60 years and then became something else. But the interesting thing about the European Union is that most people don't understand it in these terms yet because they don't have the category. They don't understand it as a two-level polity. They just don't understand it. In most cases, they don't understand it as a polity at all. Or they're trying to say that it's an incipient state federalism or it's a form of intergovernmentalism. This kind of third possibility isn't really allowed, isn't conceived of. One of the really fascinating things which is happening there, and this would also be true of other forms of regional integration in South America, in Southeast Asia, and in Africa, is that something else is happening. You know, something else is being created. You know, and let's face it, if we're talking about the Euro crisis, you know, we all know that the Euro crisis will only be resolved by the development of forms of fiscal authority at the centre, which don't exist at the moment. They can be packaged in all sorts of different ways. They can be packaged in terms of economic necessity. They can be packaged as being technicalities. But it will happen. It has to happen unless European Union implodes. At that level, then all sorts of new questions arise, because those who say that this is simply a confederal arrangement are running out of arguments. Because in just about everything that we deem to be relevant to the polity, there's been a significant transfer of power to the transnational level. But what we don't have are the structures of federal government, or indeed the structures of legitimacy such as they are, which are associated with that. So it really is quite unknown. Now, the work that I did over years on the European Constitution was trying to do something slightly different with constitutionalism, because that was in the framework of something quite settled. That was that everyone agrees there is a constitutional debate to be had about Europe. And the way in which I wanted to think about that was to say, you know, what we actually need is, it's like a Dworkinian conception of the concept idea, or the concept-conception distinction, that if we can conceive that somehow this is a constitutional entity, then we can actually have a discussion about what kind of entity it is. You know, even though it doesn't look like a state, even though it doesn't look like a confederation, even though it might need a different type of solidarity, etc., etc. What we need is a term and a framework which allows that kind of reflexive discussion to take place. You know, I think that hasn't really happened, but now, in a way, events are forcing. But a lot of people said that 5 or 6 years ago, saying that the reason why Europe won't have its, Madisonian movement is that, there's no terrible British whose yoke has to be shaken off in the Civil War. Well, what's happened is a crisis event, is a critical event, and it will be interesting to what extent constitutional discourse and constitutional language and constitutional structures figure in the solution to that event.
Here's a thought about this idea that you understand what a constitutional entity is in order to understand the phenomenon. It seems to me that there are some authors, and I wish my colleague Michael Giudice was here, for example, who talk about very similar things, but they don't mention the word constitutionalism or constitutional law. They challenge the same kind of structure of understanding. Daniel von Detlef, for example, who's now in Germany, they try to understand law. And do we have law outside the structure of the nation state? Right? You might say, well, that inquiry is bunk in the first place. We shouldn't be asking that question, but to the extent that we are, right? And the kind of considerations that they bring to play are a lot of the considerations that you mentioned here, but they're not operating within that lingo of constitutionalism. Yet it seems to me that if we understand the full picture of what's going on, we need to look at people like this who are trying to grapple with the same phenomenon, but with different words.
Yeah. Well, yeah, it's a good point. I mean, I again, in very quickly, I'll say that because other people want again. In other work, one of the things I've tried to do is to say, look, constitutionalism, as we understand it today, is about the coincidence of a whole bunch of different registers. There's a legal register, there's an institutional register, there's a political register, there's a cultural register. We need the polity, we need the demos, we need the institutional framework of government, and we need the notion of a legal order, right? And that's the history of constitutionalism has been about the coincidence of these things. When I talk about non-holistic or post-holistic constitutionalism, it's about the disaggregation of these things. It's a different way of saying what I say at the end of that paper that we lose that hinge. Okay? So the point is, there's absolutely nothing wrong with people talking about variety of legal order, as long as we don't lose sight of the fact that some legal orders come with political foundations and some don't. You know, I come from a country, Scotland, you know, which has gamed the idea of its having a separate legal order back into something which has political resonance, right? So there's all sorts of complexities and ironies in the relationship between having a legal order and having a political order. But I think, you know, we learned a lot from understanding, from drawing it, from people like Giudice and all the rest of it, drawing their pictures of legal order. But there's something missing in that picture as well, which has to be filled in.
Which is the constitutional.
Well, which is the other parts of the constitutional, because that is part of the constitutional. I wouldn't want to say that isn't part of the constitutional.
Professor Berger, yes.
Thank you. One of the elements I found most sort of useful in the paper was, and in the presentation today, was kind of structuring the play of the symbolic language and using that as a central part and meditating on that for a while before you got to these other questions. So the question is, in a sense, a simple one. It's kind of to get a sense of the larger architecture or the economy of that symbolism. And specifically, two terms that I'm wondering about is the rise of the symbolic import of constitutional in the context of global constitutionalism. What effect has it had on its configuration, it being like constitutional, with the concept of, or the use of the language of sovereignty on the one hand? So what's been the kind of dynamic between those? And on the other hand, I also wonder, has there been an impact in the sort of arrogation of the language of pluralism into constitutional pluralism back on pluralism itself? That is, our kind of claims in kind of the conventional or the pre-existing debates around legal pluralism kind of pushed up into a constitutional register by the success of language around global constitutional pluralism.
Can I start with the second question? I think, intriguingly, not very much. You know, I think there remains a kind of, not only at the intellectual level, a level of kind of mutual ignorance. I did a course when I was at the UI on legal and constitutional pluralism, trying to bring together these literatures, and it was tough. It was a tough job, but also trying to not just try, because in a sense it doesn't matter if I bring together the literatures, but what you would like to see are circumstances where, in practice, people are thinking about the same thing in a way which merges these different sets of ideas. There's not an awful lot of evidence of it, you know, because, and I think that goes back to the point I made earlier, that constitutional pluralism, first of all, it tends to be trans-order, and secondly, it tends to be based upon an idea of the chauvinistic authority of the particular order, which sits unhappily with the softer language of legal pluralism. You know, so that's part of the issue. What was the first question? It was an interesting question, but I've lost it. The first question,
just the effect of the focus on a particularly European form of
on
constitutional,
sovereignty,
on the use of even the tethering of constitution and sovereignty, or the use of constitution and sovereignty.
I think what's happened, I think we were talking about this earlier, I think there's a sense in which constitutionalism is clearly one of the languages in the European context which challenges sovereignty. You know, it just does. And it does it as much, I think, in the context of human rights and the European Convention of Human Rights as it does in the context of the EU. Interestingly, I don't think when you move to the global level, and where, let's say, again, because the challenge to sovereignty can be a good thing or it can be a bad thing. You know, the challenge to the sovereignty of a small, weak state on the part of some sort of coalition of the willing isn't necessarily a good challenge to sovereignty. You know, there are different sorts of challenges to sovereignty. The challenge to sovereignty in terms of humanitarian, genuinely humanitarian intervention is a better type of challenge to sovereignty. I would say that in the context of the of those forms of international law, of global law which challenge sovereignty, very few of them take place in the name of something called international constitutionalism. International constitutionalism remains an aspirational discourse of a number of international lawyers, rather than something which actually, you know, has traction within practice. Within the European context, and not just the European context, but in the context of the ECHR and the EU, there's a way in which, you know, the meta-discourse of constitutionalism has actually entered the discourse of the actors themselves. You know, and people will say, you know, claims will be made, you know, that national sovereignty is being challenged in the name of a broader constitutional discourse.
Okay, so we have run out of time. So please join me in thanking Professor Walker and Professor Zumbansen.